On June 18, 2020, the U.S. Supreme Court sided with DACA recipients, ruling that the way in which the Trump administration rescinded the DACA program in 2017 was unlawful. The decision is a huge victory for immigrant communities and their allies who mobilized to protect the DACA program. Although the court sided with DACA recipients, it is important to remember that the Trump administration can again try to end the program through an executive action. While only Congress can take action to create a permanent solution for DACA recipients through federal legislation, we must also continue demanding that state and local officials protect our communities from immigration enforcement. It is time for a permanent legislative solution for DACA recipients, TPS holders, and all other immigrants at risk of deportation. What did the court decide? The court ruled in favor of the DACA program, rejecting the Trump administration's 2017 attempt to terminate the program. This decision restores the program completely, and both initial and renewal applications should be accepted by us. What does this mean for the community? Current DACA recipients continue to be protected from deportation and eligible for benefits under the DACA program, like work authorization. Eligible DACA recipients can continue to apply to renew their DACA for 2 more years. Eligible individuals who never had DACA should be able to apply at this time. All eligible individuals should consult with a legal service provider for information about applying for DACA for the first time, renewing their existing DACA, and/or getting screened for eligibility for other, more permanent immigration options. It is possible advance parole may again allow DACA recipients to travel outside the United States and return. However, details of this possibility are still unclear, and the potential impact of the COVID-19 pandemic may limit the ability to travel. Check with a legal service provider for more information. What should the community do now? Connect with a legal service provider to apply for DACA for the first time, renew DACA cases, and explore options beyond DACA. Visit bit.ly/INMLP to find a trusted legal service provider. Continue to fight this administration's anti-immigrant agenda by advocating for a permanent legislative solution for DACA recipients and all other immigrant communities at risk of deportation. Join digital rallies, discover helpful renewal resources and funds, and more at our #Home is Here partner page. Latest in DACA understanding the 2020 Supreme Court decision on DACA June 18, 2020 DACA Community Resources on June 18, 2020 the U.S. Supreme Court sided with DACA recipients ruling that the way in which the Trump administration rescinded the DACA program in 2017 was unlawful. The decision is a huge victory for immigrant communities and their allies who mobilized to protect the DACA program. Although the court sided with DACA recipients, it is important to remember that the Trump administration can practice alert, temporary changes to U.S. Citizenship and Immigration Services, USCIS, in response to COVID-19. May 28, 2020 Asylum Citizenship and Naturalization DACA Public Charge Family-Based U-Visa, T-Visa, VAWA. This practice alert provides a brief summary of temporary changes U.S. Citizenship and Immigration Services, USCIS, has made in response to COVID-19. Changes include suspension of all in-person services including interviews and biometrics appointments, acceptance of photocopies in place of original signatures, extensions for requests for evidence, RFEs, notices of intent to deny, NOIDs, and Annotated DACA Application Guide March 23, 2020 DACA Community Resources. This guide is for individuals whose DACA expired after September 5, 2016 and are looking to file a renewal application in the coming months. The guide includes annotated forms I-821D, I-765 and I-765WS which form a renewal application packet. If an individual's DACA expired on or before September 5, 2016 nor was DACA terminated, they will need to file an application as a renewal initial. This ILRC submits comment on USCIS fee rule December 23, 2019 Asylum Citizenship and Naturalization DACA Family-Based Immigrant Youth Policy Advocacy U-Visa, T-Visa, VAWA on December 23, 2019. ILRC submitted a comment on opposition of the Department of Homeland Security's Notice of Proposed Rulemaking titled, U.S. Citizenship and Immigration Services fee schedule and changes to certain other immigration benefit request requirements, published in the Federal Register on November 14, 2019, with supplemental information published on December 9, 2019. The proposed Public Charge Exemptions and Considerations December 17, 2019 Family-Based Immigrant Youth DACA U Visa, T Visa, will public charge after rulings by the U.S. Supreme Court on January 27, 2020 and February 21, 2020, the Department of Homeland Security, DHS, was able to implement its new rule relating to the public charge ground of inadmissibility nationwide. The DHS rule went into effect for adjustment of status applications filed on or after February 24, 2020. On February 24, 2020, the Department of State, DOS, also